Okay, let's get going. I think many people are on the call now. A few more may well be joining as we go through. But thank you everyone for joining us this morning for our employment law update. And we'll be hearing from Victoria, Regan and Elaine Abbs in our employment team very shortly. Just a brief intro and a little bit of housekeeping from me before we get underway. So yeah, my name's Scott Garner. I look after the business development team here and the marketing of the firm at Rix & K. I know many of you on the call will be very familiar with the firm, but for those of you that aren't, just a quick intro into Rix & K. We're a mid-market law firm that provides the full suite of commercial services to businesses. And we also have an extensive private client offering working for the owners, the directors and individuals and families, providing private client services to those individuals. We have offices based throughout Kent and Sussex. As I said, we'll be hearing from Victoria and Elaine in a moment, and I'll pass on to them to do their own introductions. Just a little bit of housekeeping. We are recording the session. We're also going to run a Q&A at the end of the session. So if you have questions as we go through the presentations, please use the Q&A function within Zoom, and we'll pick those up at the end. If we have an abundance of questions and can't get through all of them on the call, we will come back to you one way or another, and we'll make sure we pick those up for you. So that's very good. Just a quick sort of promo out really around our Gatekeeper HR offering, just to make sure that everyone is aware. We have a fixed cost retainer offering, which is called Gatekeeper HR, where we have a huge online portal of resources that contains president documents and a whole suite of HR documentation and access to an HR team and obviously our lawyer team, which includes Victoria and Elaine. All of that detail is on www.gatekeeperhr.co.uk. If you're interested, do take a look. It's a really excellent service. Okay, we're going to crack on with the presentation. So I'm now going to hand over to Vicky, who's going to take you through the first part, and then we'll hear from Elaine. Thanks very much.
Lovely. Thank you very much, Scott. Good morning, everybody, and welcome to this morning's webinar, which is an employment law update. For those of you who don't know, my name is Victoria Regan, and I'm a partner in the employment team at Rix & K. So what I'll be looking at is some cases that have happened over the last 12 months or so. We've had a significant post-Uber decision in respect of status. The status saga continues, where we've actually had the appeal tribunal provide clarification on the worker status test. So with this, Sejpal was an NHS dentist on an associate's agreement. Whilst she was on maternity leave, the Kensington office in which she was placed was closed, albeit she was not redeployed with the rest of her colleagues. She said that this was directly linked to pregnancy and because she was on maternity, and as such wanted to bring claims for that. However, in order to be able to bring that, she had to be able to prove that she was a worker and that she did have protection under the Employment Rights Act, Equality Act. In order to do that, she had to prove that she was under a contract to perform the work personally, and also that the dental practice was not a client or customer of hers. In the first instance, the tribunal found that she was not a worker and therefore could not bring these claims. They didn't think that she was under a contract to provide the work personally by virtue of a substitution clause. She appealed. The appeal tribunal disagreed with the tribunal and actually said there was clearly a contract for her to provide some personal service here. On looking at it in more detail, the substitution clause actually wasn't an unfettered right for her to be able to put anybody in her position if she wanted to. It was only after 14 days of her being absent and only a locum who was actually acceptable to the practice. And also the tribunal found that the tribunal had somehow, it was an erroneous approach. It should have been more of a holistic approach. And they'd actually ignored the other worker tests that they should be looking at. So assessing the level of control between the parties, the level of integration, and they completely ignored to look at whether the practice was actually a client or customer of Sejpal. So therefore, it's been sent back to another tribunal to decide again. Next slide, please.
Hi, Vicky. Sorry, can you not see the slides?
No, I've only got the first one through.
Oh, bear with me. Sorry about this, ladies and gentlemen. We're just trying to get the slides sorted. Which slide can you see then?
So Sejpal. And it's the next one, please.
Okay.
Lovely. Perfect.
Yeah.
Thank you.
Okay. Good.
Okay. So as expected, we're now seeing a rise in the number of cases coming through COVID-19 related dismissals, more specifically where employees have said they've raised concerns, health and safety concerns, and they've had genuine fear of a serious and imminent risk of danger in being in the workplace. So with Gibson, there was a chef who was furloughed in the first national lockdown. He was asked to return to work. He confirmed that actually he was concerned to do that due to the fear of catching COVID and passing it to his father, who was clinically vulnerable at the time. He also raised concerns about lack of PPE and working in non-secure COVID-19 working environments. Nothing had been put in place. Ultimately, he was summarily dismissed by text, and he brought a claim for automatic unfair dismissal. And the tribunal found that he was successful in this because there was a genuine fear of this serious and imminent danger. He raised concerns about lack of PPE, and also there was a growing prevalence at that time of COVID, and also the risk of significant harm to his father if contracted the virus. Therefore, it was a reasonable and genuine belief, and as such, he got this protection to bring the claim. And then in contrast, please, Scott, with the next slide, the case of Rogers. So Mr. Rogers decided to leave work and say he's not going to return because he had vulnerable children at home. However, the company had actually undertaken a risk assessment. They put safety measures in place, staggering start times, masks, social distancing, etc. Notwithstanding that, Mr. Rogers said, not going to return until lockdown has eased. Didn't give any other reasons. And as such, after a month, he was dismissed. And Mr. Rogers had under 2 years continuity of employment, which is important because automatic unfair dismissal claims can be brought as a day one right. However, he was unsuccessful because the tribunal found that he didn't have this reasonable or genuine belief in the serious and imminent workplace danger. He hadn't mentioned anything specifically before. What also influenced the tribunal was the precautions that had been implemented by the company, as recommended by government, but also by the claimant's actions. He hadn't mentioned any specific workplace concerns or dangers. He hadn't taken any steps to try to avert any alleged danger before absenting himself. And it was actually found that he breached the self-isolation rules by driving a friend to hospital the next day, being quite happy to be in a pub. So it was found to be more of a general concern about COVID as opposed to a workplace-related concern. And as such, he did not get that protection. Next slide, please. So whether long COVID equates to a disability has been a bit of a grey area. However, this month, this was actually considered in the Scottish Employment Tribunal. And this is disability for the purposes of the Equality Act. So Mr. Burt was a caretaker, security for a charity, been there 20 years. And initially, when he caught COVID, the symptoms were mild. But then latterly, it developed into more severe symptoms after his self-isolation period. The severe symptoms, needing to lie down because of fatigue, unable to perform just the normal household chores, ironing, cooking, shopping, unable to go to the local shop to get a newspaper even. His fit notes referred to long COVID, post-viral fatigue syndrome, and occupational health actually on 2 different occasions said that he was fit to return to work and unlikely to be disabled. He was dismissed on grounds of ill health because he was unable to return to work, and the Employment Tribunal found that he was disabled for the purposes of the Equality Act. There was a significant adverse effect on his day-to-day mobility and activities, and it's likely to be long-term. So As such, he was able to bring a disability claim on that basis. This is obviously only a first instance finding, and it's not binding, but definitely watch this space for further cases on this point. Next slide, please. And then just a little reminder about following procedure. The case of a service chef, Mr. Riney for Java Crest. He had an accident, broke his shoulder, couldn't return until April 2020. Obviously, we had lockdown in March 2020 when he was furloughed. And after that period of time, the company experienced serious decline in turnover. And so the general manager saw fit to, on Facebook, let all staff know that they would be reopening, but on limited hours with a restricted menu, and redundancies would be necessary. Some staff returned to prepare for reopening and to help out, whilst others, like Mr. Riney, remained on furlough. Rather than undertaking any form of consultation or selections or pools or criteria, the company decided simply that they would just retain all the staff that had been helping with the reopening and make all those on furlough redundant. Mr. Riney appealed because of his lack of consultation and process and was unsuccessful. He brought a claim in the Employment Tribunal for unfair dismissal and was successful. The reason being, obviously, it was clear that there was a redundancy situation. However, when considering the fairness of the procedure, the lack of consultation, it then made that process unfair. And they were also very critical of the notification on Facebook about redundancies. So just a reminder about process. Next step, please. And then quickly on sex discrimination, Ms. Macken was a junior employed in 2013 on 120,000, perhaps not bad. However, when she found out that a male colleague in the same role in the same year was actually employed on 160, she thought there was an issue. There was also a bonus disparity. When I say disparity, Macken received £33,000 and the male comparator received £237,000, quite a big difference. She also received sexist comments and incidents and dismissive comments as well. She raised grievances, but these were ignored. And then in the Employment Tribunal, it was found, yes, there was sex discrimination in respect to the bonus. They tried to say the bonus was because of poor performance reviews. However, leading to victimization, she only received poor performance reviews because she'd raised complaints about her managers. There was obviously an equal pay difference, and they found that that was because of gender. And in addition, they made a further finding that they'd failed to follow the ACAS Code of Practice on Disciplinary and Grievances. And as such, they awarded a whopping £2.8 million in compensation. Next slide, please. And some of you may well have heard about this latest case in the press, and this is harassment related to sex. So this is where we've had an electrician, Mr. Finn, had been working quite happily for 24 years without any issues. And then he had some arguments with his supervisor, resulting in threats of violence and being called bald, followed by an expletive. He said that he feared for his safety following these events, so told management and went home. He was dismissed for gross misconduct. Quite strangely, it was because it was alleged that there'd been a breach of trust and confidence because he'd written a statement to the company about events, having been assisted by his son, who worked for the West Yorkshire Police, and it was written on their headed paper. They deemed this to be an attempt to intimidate, or further, that he'd actually made a statement to the police, and again, that was unacceptable to them. He obviously said this was not the case, but they ignored this. He brought a suite of claims against the company, but the main issue here is about whether calling somebody bald and the way in which it was said, whether that equated to harassment. So looking at the test, they thought, yes, it did actually meet that test because the comment had crossed that line. It was actually becoming more personal about his personal appearance. So it's a bit of a step too far. So was it unwanted? Well, yes. It violated his dignity. Was it related to a protected characteristic? And they found yes, and that being gender, because it was found that baldness was probably more prevalent in men than women. And then was it offensive? Yes. And obviously then had a way of producing an intimidatory, hostile, degrading, offensive work environment. And all of those then meet that test for harassment. So just a little reminder, really, even about the dangers of workplace banter and providing a safe and working environment for all staff. Next slide, please. And then finally, obviously, whilst previously we've had quite a few employment tribunal decisions confirming that staff with strong menopausal symptoms could possibly qualify as being disabled, we've now just had the first appeal tribunal decision confirming this. So this was the case of Miss Rooney. She was a childcare social worker. She'd been there since 2006 until she resigned in 2018. And she was suffering severe symptoms, but she resigned saying that she felt unsupported and was subject to unfavourable treatment during menopause. She said she suffered obviously physical, mental and psychological effects of these symptoms and had been for 2 years. So symptoms such as insomnia, lightheadedness, hot flashes, anxiety, sleep disturbance, but also those symptoms had then led her to forget to attend events and meetings, leaving handbrakes on her car, leaving the door unlocked, leaving windows open, leaving cookers and irons on. She was generally struggling to cope with everyday life. So went to the employment tribunal, and in the first instance, they said that she wasn't, it doesn't equate to a disability. Ms. Rooney then went to the appeal tribunal on this point, and they overturned this. They said that the employment tribunal had actually incorrectly analysed the symptoms in respect of the definition under the Disability Act. And just as a reminder, for disability, for physical or mental impairment with an adverse or substantial and long-term effect on a day-to-day activities, long-term being 12 months or more. The appeal tribunal was a little confused as to how the employment tribunal came up with this decision, because these were not just minor events. It did affect her quite significantly and had been in excess of 2 years. They said that actually, on that basis, they hadn't even looked at the evidence, hadn't contested the evidence, so it has to be remitted back to the employment tribunal. What they did say, though, as a little reminder, is that the next decision required careful and factual analysis. So it'll be quite interesting to see if the employment tribunal comes up with the same conclusion. And thank you very much for listening. And I'll now pass you over to Elaine. On mute, Elaine.
Sorry. Hello, I'm working in the Ricks and Kays Gatekeeper HR team, and I'm working with Vicky. I've come here to go through what we consider is useful for you to know since April last year to date. And some of what I'm going to say you will already know, but we think that it's useful for you to just have a bit of a refresher on some things, and then I'm identifying what you should be looking at going forwards. So immigration law, starting with that, many of you will be familiar with the huge amount of changes that have taken place over the pandemic, because the government has had to put in some temporary measures. And so I'm going to talk through what you need to do now. And I'm sure because we're past April the 4th this year, you will already have been looking at these yourselves, but I'm going to just give a refresher. And then at the end, I'll mention some things about that. So from 6th of April this year, employers must carry out a right to work check on all workers and employees engaged after the 6th of April and employees and workers with a time-limited statutory excuse, that word will be familiar to you, which requires a repeat right to work check. So when the right to work check is complete, employers, importantly, will have a statutory excuse against liability for a civil penalty if they're found to have employed someone illegally. I'll go through the sanctions at the end. Next slide, please, Scott. Thank you. So employers have to take a right to work check on prospective employees and workers, including British and Irish nationals and settled migrants. So that you may not think you do have to carry out a check on a British and Irish national and settled migrants, but you do. So you have to include it when you're going through the process of looking at somebody's right to work. You really must look to make sure that when you're considering who to make the check on, there's no element of discrimination. Now, anyone who's dealing with making the checks and recruitment in your organisations really must start with the government guidance on this. So I've put a link, which is impossible for you to interpret because it's so small, but you just need to put in government guidance on right to work checks. And the latest version was issued on the 6th of April this year. It was slightly updated on the 27th of April because it included the checks on Ukrainian nationals, which come into force. And it includes, it's a much more accessible version. Next slide, thanks Scott. So everyone needs to be familiar with that government guidance. It's 72 pages long. I'm really sorry, but it's important to read if you're dealing with recruitment. So there's 3 ways of carrying out the right to work check. 1, is a manual right to work check. 2 is using the new digital system, which is the identity service provider method. And 3, it's a Home Office online right to work check. So the manual right to work check, so that's actually looking at documents and not looking virtually. They cannot be used. This is the big change. They cannot now be used for holders of a biometric residence card, a biometric residence permit, frontier residence permits, and most EEA citizens. So that's an important change. Go ahead, Scott. Thank you. So carrying out a manual check. So before 30th of September this year, there's still a remnant of the previous regime. So I thought I'd go through that before we go on to the 1st of October manual document check. So I won't read through all of this, but I've set out here how employers must go through this. So you have to obtain scanned documents, and so when I say scanned, that's the difference between what's going to happen from the 1st of October. You can obtain scanned documents and not original documents. Importantly, at the end, you have to arrange that video call, which many of you have been doing up until now. So that's with the current or prospective employee, and asking them to hold up their original documents. So importantly for your records, you have to retain clear and dated photocopies of the original documents on file on your personnel records. Next slide, thanks. So from the 1st of October, you have to obtain original documents, and all of these documents are prescribed in the government lists. The latest prescribed lists, of course, need to be checked, and that's in the government guidance document available online. So check the original documents, as I say, and then also you have to keep a clear and dated photocopy of the original documents on file, and you have to carry out the check in the presence of the employee. Thanks, Scott. Next one, thanks. So using the identity service provider for the check, this is the thing that the government wants, in fact, all employers to use in the future, because they're trying to digitize the whole system. At the moment, you can only use this system for British and Irish citizens with a valid passport or passport card. So it's the employer's responsibility, not the employee's responsibility, to obtain this identity virtual check, so validation check. So after carrying out the check via this service provider, employers must satisfy themselves that the photograph and biometric details, such as date of birth, are consistent with that person presenting themselves for work. Thank you, Scott. Next one. Lastly, the Home Office right to work, online right to work. So this looks like a very long, boring slide, but I had to put everything in. I'm sorry about that. So, not all individuals have the immigration status, which needs to be checked online by this service. But those for whom this method is necessary, word underlined, includes those with a e-visa, a BRC, which stands for the biometric residence card, slightly losing my memory on these. So BRP, biometric residence permit, and the frontier worker permit, which probably you'll all be familiar with. So the checks are carried out online in advance of employment or in employment by an employee or worker who receives a share code. And I think you'll be familiar with that, everybody who's here today. So the code can actually be sent to an employer by the system itself, and employees or workers don't need to actually physically give or the number to their employee, because it can come via email to the employer. So that the check once done via this Home Office online portal, employer has to satisfy themselves that the individual presenting themselves is the same person as the person they checked. And then importantly, employers must check there's no condition which prevents employees or workers from working in the UK. That's the last thing that's really vital. So the statutory excuse will be there if these methods are used. Next slide, thank you, Scott. And then the retention of records is absolutely vital to know. Employers must keep them securely for the whole of the employment, and then for 2 years following the end of employment as well. Thank you, Scott. So sanctions, I'm not going to go through them now because we don't have time, but I have set them out on this slide. Absolutely, absolutely important for you to know this. The government are checking up. We're doing it at Rix and K. We know we have our clients who are coming to us and they tell us that people are being checked up on. So they're coming to us to say, oh, our process is correct. And there we go. Very important. Next one. Thank you, Scott. So gender pay gap reporting, I've only put this on just to go through this very briefly, because in the pandemic, the deadline for 2020-2021 was extended to the 5th of October 21. But the government are not going to check up that deadline was made until after the deadline for the next year. And that deadline is the 4th of April 2022. And I lastly wanted to say that the highly anticipated review of the gender pay gap reporting system wasn't mentioned in the Queen's speech this year. So we don't know when that review is going to take place, but watch this space. Thank you. Thank you. So the interesting facts in regard to gender pay gap is that everyone thought the pandemic was going to worsen inequality. They were proved right, but on the pay issue, the statistics are showing that there's a downward trend. So I've just put those statistics there. That in April 2020, they went up they went down slightly, but in 2019 they were 9%. So latest are 7.9%. So on all the reading that I've done, it says that there's a downward trend. And then the next slide shows some interesting things I wanted to point out. There's a large difference in the gender pay gap between employees aged 40 years and over. There's the difference 40 years over to those below 40 years is so much bigger. There's reasons for that, so you can read the literature on that and a report that's been put out. So compared with lower paid employees, higher earners experience a much larger difference in hourly pay between the sexes. So these are things that still need to be remedied. Next slide, thank you. So the IR35 requirements from the 6th of April 21, I think everybody will know these already. We went through them at the last seminar last year, but I've put a reminder up. And so what happened last year in April to IR35 and applying that to the private sector, it is still in place clearly, and nothing has changed since then. So if we go through these two slides, Scott, because I need to just set those out, because we have clients come to us to say, am I caught by IR35? So we're giving advice on that. And it is important to check whether your contractor is caught by IR35, because employers mistreat payments to the client as salary. So that's clearly important, making the HMRC deductions. Next slide, thank you. So the exemption from IR35, I think small businesses who know they're small businesses, as defined in the Companies Act, will know that there's an exemption. And so look out, looking out for an intermediary is not so much necessary as it is for a medium and large size company. So I put at the bottom, a small business can grow, keep checking whether the IR35 rules need to apply. If a company is growing, then there's a 2-year sort of grace period to get yourselves in order to comply with IR35 if you're going to go over the criteria for a medium to large size company. So next slide. I wanted to just say that the CEST system, which the government has set up for the assessment being online, has come into great criticism in the latest report. Government are looking at CEST, and they're going to try and iron out the difficulties of that, because what's happening is CEST is prematurely identifying contractors as outside IR35, and that's a problem. And it's difficult for individuals to make challenges in the courts, and there's no appeals procedure for contractors wishing to challenge their assessment. This is a problem, and it's been looked into. So what employers really need to do who come within looking at whether IR35 is applicable, if they're a medium to large size business, they need to look at the common law tests to determine employment status. And I think some of the audience will already know what those are. Next slide, thank you. So the national living wage eligibility, just wanted to say that that previously only applied to those over 25, but that's now applicable to the 23-year-old and over, so you need to make sure they get that right. The national living wage hourly rate is £9.50 per hour, so, and it doesn't apply to those who are self-employed. And by 2024, the government intends the statutory minimum wage rate to be 66% of median wages. We're quite far off that at the moment. Next slide, thank you. So employment law changes to look out for. Start slightly whizzing because I've only got about a minute. I wanted to just say that in the future, over the next year, what was in the employment bill, we're not having to prepare ourselves for so much. Because the employment bill wasn't in the Queen's speech. It was highly anticipated. There have been many consultations on all the proposals that were going to be there. So it's disappointing for many people they weren't. So just to say, there are some other things to look out for. So at 6th of April 22, the introduction of a portable 3-month flexi job apprenticeship scheme, which is great for apprentices. Government's recent announcement, please look out for that, mitigating strike action, staff shortages. They've recently said, as most people would have heard, that they may introduce the suitably trained agency workers provision, so that is going to make things manageable. But the unions are saying that this is not going to be workable, because to replace trained workers is going to be difficult due to the labour shortage. On menopause, the Minister for Women has actually announced that she does not have any plans. There are no plans to make any change to the Equality Act to make menopause a protected characteristic. As Vicky has mentioned, a case on this, and there have been a huge upsurge in cases being brought in employment tribunals with women who suffer from the menopause. The government are going to look and consult with the EHRC in that area. The statutory code of practice has been announced on fire and rehire, but there's no time limit. On digital fit notes, please look out for that. You'll be able to get them digitally. And then lastly, the ICO, Information Commissioner's Office, is going to issue updated employment practices guidance in 2022, because it hasn't been updated since 2018. That's it for me. Sorry for the whistle stop tour.
Okay, great. Thanks, Elaine, and thanks very much to Vicky as well, who have taken you through the session. I'm just looking on the Q&A. We haven't had any questions put forward, so I'm assuming everyone has got what they needed out of the webinar. There were a few links in some of the slides that Elaine presented. We will pass the slides around so you have the notes and the links to the government guidance and all of those types of bits and pieces. And we will be sharing the recording of the webinar online once it's been topped and tailed. So look out for that if you want to recap on anything. And of course, you've got Vicky and Elaine's contact details on the screen there. We'll send them around as well after the session. So if you do have questions that you don't want to raise in the webinar, but want to pick up with Vicky and Elaine, by all means, get in touch. They'll be happy to have an informal conversation with you and chat around any issues you might have. So I think that's it from us. Thank you very much for joining. Hope you found that useful, and we'll see you all next time. Thanks very much.
Thank you.
Thanks, everybody.